Hello and welcome to On the Spot. My name is Patrick Kamara. We are coming to you from Nyakisharara in Mbarara Municipality, or you can call it Mbarara City. We are at the home of the retired Chief Justice, the Right Honorable Bart Katureebe. We are here to touch base with him and find out the last 5 years when he was holding fort as Chief Justice. How was it like? And what next for him as he goes into retirement? This is the special edition of On the Spot. Welcome to the show. Thank you very much, Right Honorable Chief Justice, for having allowed us into, and our cameras, into your serene home. Thank you very much.
You're welcome to my very humble home.
Yes, I can see it's humble, but it's grand, everything mixed together.
Thank you.
And it's what a nice place for you to retire from. Now I know why you are hurrying to retire.
I was not hurrying to retire.
Now I know why.
I made 70 and I retired.
Now I know why you hurried to come right into the village, because this is a place where you can unwind.
Yes, that's true.
But that aside, this interview, whereas I've had an opportunity to interview before, I think I'm not going to hound you like I always do. I just want now to understand the man, because you're 70, you're retired, so I think I should take it slow. So what next, Right Honorable?
What next? One has to look back at what one has gone through. Out of my 70 years of life now, take off the first 25 years of study, that leaves you 45. And out of the 45, take off 9 or 10 that I spent in private practice. So the rest has been public service.
Public service.
Public service. 8 years in the Attorney General's chambers, 13 years in the government, deputy minister, full cabinet minister, in the parliament, in the Constituent Assembly, then 15 years in the judiciary, the last of which as Chief Justice. So that's why I say nearly 36 or 38 years of public service. So what next is to relax, to reflect on my life, on what I've been able to do, what I failed to do, what could have been better, or even where I succeeded. This is a time for me now to sit down and relax, come here, look after the goats and the cows. When my grandchildren come, play with them.
But surely, in your profession, there hasn't been anything maybe you failed to do. As a lawyer, I suppose, every lawyer will look towards becoming a judge, an Attorney General, and now Chief Justice of the Republic of Uganda. That was it.
Well, you can get...
In your profession, you hit the pinnacle.
Well, you can say that, yes, if you are a lawyer. I imagine the dream of every lawyer is to head the bar. And if you have become Attorney General and been appointed as senior counsel, that, I believe, is a satisfaction in itself in terms of achievement. If you become a judge and you go to the Supreme Court, the highest court in the country, and then head the judiciary as well, so heading the bar and then heading the judiciary, in that sense it's an achievement. But when I talk of what you have been able to do, it is what we do in those offices. Do you feel satisfied that you have achieved something? Have you done something? Are there things you could have done better? Yes, I'm sure everyone feels, when they reflect on their lives, things they could have done better, things they succeeded where they probably didn't think they would succeed, and things where they failed.
I just want to know, for a man who has been able to reach the pinnacle of what you've reached, I wonder how was it like growing up in Ruberizi, understand from a very humble background?
Yes, and that sometimes I reflect myself when I used to go out, right from when I was still a state attorney and to attend a conference, and you had the Uganda flag in front of you. Sometimes I would ask myself, is this really me? The fellow that used to graze goats in Bunyaruguru barefoot. I never put on shoes until I was in secondary school here in Mbarara. So, and you ask yourself, is this really me? Have I come this far? Yeah, but you thank God for it. It happened. I'm sure many other Ugandans who have gained positions of leadership are not any different from me. We all mostly come from peasant homes. My parents were just peasants. My father had a paid job because he was cooking for the priests, for the white fathers and later the African fathers at Ruga's Parish. And that exposure to the education, to the priests, enabled him to put all of us, all his 6 children, to school. The last born of all my father's children, and I have reached where I've reached.
From Kitunga High School to the then prestigious school of Namilyango College.
Namilyango College, yes.
You must have been an A student throughout.
Well, I did well. I don't think I was necessarily an A student, but I worked hard and I did well. And I remember when I was at Kitunga, after S4, my then headmaster, Mr. Motram, wanted me to put in my choice at Intare. He had been a teacher at Intare before he was posted to Kitunga as headmaster, and to him Intare was the next thing to go. So he was very surprised when I told him I wanted to go to Namilyango. I had my own reasons for going to Namilyango, but he was very surprised and said, okay, and I came to Namilyango.
And I'm looking at you from Namilyango, you joined Makerere universities.
Yes.
Quite a number of your colleagues, their sort of political activism were nurtured at the university at Makerere. You know, they're involved in student politics and all that. Was that the same? Was it the same with you?
In a way, yes, because we joined university in 1971 when Idi Amin had just taken over. And at that time, the politics was a bit muted because of what had happened, the military coup. But I do remember that Makerere University Students Guild was the only organization, I think, that did not write a letter of support to recognize Amin and so forth. And then Amin came to address us at the university and so on. But then the following year, when we were in second year, the student campaigners picked up, and we had the liveliest debate at that time between my good friend Eli Karhanga and the governor of the bank, Tumsime Mutevire, and Mary Waiswa, who is now vice chancellor, who was the only woman candidate. Very lively politics. And I participated. I was campaigning for Mutevire, and I stood and was elected a member of the Guild Representative Council for Mitchell Hall. So I did participate in student politics at that level. I was a member of the GRC for 1 year. After 1 year, our turn, then we had the election of my good friend Olairo Tuno, was my classmate, and then he didn't complete his term. He had to run away to exile, and things went haywire, and we were finishing, and then the rest is history.
So it looks like the political activism, or maybe the liking for politics, the seeds were sown at Makerere. Because I'm saying that, and let me read this because I've seen your illustrious career serving Uganda, holding several ministerial positions like State Minister of Health, State Minister for Regional Cooperation, Cabinet Minister for Justice and Constitutional Affairs, Attorney General. You also represented Bunyaruguru County, which is, I think, Rubirizi now in the Constituent Assembly. What is it, the Right Honorable Bart, that really made you stand out most of the time to be in all these 3 arms of government?
I don't know. I don't know. When I finished Makerere, and that was really 74, and the situation was really, then I finished the Law Development Center, I joined the Attorney General's office. So I became a civil servant, I was a state attorney. So there wasn't much politics to play anyway. Now, in 79, we all celebrated the fall of Idi Amin. We hoped things would get better. But I still did not join active politics. No doubt to friends I expressed certain opinions and so on, but I did not join. I was of the view that the UNLF idea should have been given chance to take root, because the factors that had brought Idi Amin were still there. And we thought a united front, I for one thought a united front, the UNLF, stood to give Ugandans a chance to take a breather. What they had called the Moshi spirit should have been given a chance. So I was very disappointed when that broke up and went to political parties. I never joined any political party, and I've never joined any to this day. I've never belonged to any political party. I do sympathize with certain ideas, no doubt, but I've never...
But for a person who served in Museveni's government even before NRM became a party, for sure, if the same people who are now in NRM are the same people you served with.
No,
so
but
we can say that the Right Honorable Bart Katureebe was inclined to the NRM.
You can say that, but to begin with, the movement, the national resistance movement.
But really, with all intended purposes, it has always been a party. At one party state, and maybe now we can say it's a multi-party dispensation.
Let me give you, when I was a deputy minister in the Ministry of Foreign Affairs,
yes,
my minister was Kawanga Semogerere. When I first got appointed a deputy minister, the national political commissar who gave me assignments, I remember one time being sent to read the president's speech in Kotido, was Chiza Besige. So that's the movement.
Yes, but all those two gentlemen woke up one day and smelled the coffee and realized this was a party, and all along, and they knew they had left, they were living a lie.
Now, let me tell you, you can ask them about that.
I have never asked them, sir.
They can say that. But what I'm saying is there was something called the National Resistance Movement. There were efforts made which succeeded to transform that into a party. And consequently, you remember there was the saying, let them go, others left and others came in and so on. But I think there is a difference between what was taking place. If you look at the debates in the 6th Parliament, for example, when we were still talking over the movement, much as there were people you regarded as opposition and so on, but I thought the movement idea was still very strong.
Yeah, but there are still some people in this country, Right Honorable, who still think that NRM of then is the NRM of today. It is still a party that infused in with the state, a hybrid of sorts,
well,
because it is still a state
but
fused into the party.
I have also had people who have said the NRM we served in is not this NRM. Those voices, I'm sure you.
Because by then there was no any kind of doubt. You just know it was the state party in control and it was one. But now they're trying to leave. According to some political analysts I've seen, there's that kind of frustration, because if you see individuals in public offices who now we are going to get into elections, and when they get involved actively into politics, and yet they shouldn't, it really looks, by all intent and purposes, as a party but infused into state. However, you no longer with it. I'm only asking when you determined to work with them then, because now you've stepped into the hallowed ground of the judiciary, up the helm of heading it.
Yes,
do you look back with some kind of maybe regret?
No, not at all. Because as I said, I supported the idea of the UNRF in 1979. And the closest to the UNRF idea was the national resistance movement when it came from the bush. And when I was invited, I didn't apply, when I was invited to join the government as a deputy minister, I welcomed it as a chance to serve and try and do my best, which I believe I tried. And then the people in Bunyaruguru who had never had someone from Bunyaruguru represent them in parliament, because people who represented in Bunyaruguru always came from outside. First we had the late Bazirio Wataringaya, came from Igara, but the way they used to do the constituencies at that time, he was the one representing Bunyaruguru. Then later we had...
I wonder what you mean that he was the only one representing Bunyaruguru. Should we be having the ethnicity as part of representation? Because there was a geographical entity that included Bunyaruguru.
Yes,
and so even if he was from Igara, he was still your representative.
Actually,
only that it was a bigger geographical sphere that he was representing.
No, but one of the criteria for standing in an election, at least the law today, is you must be having a home or you come from that area.
Yes, right honorable. He was coming from that area.
He didn't.
Because the constituency was bigger.
Yeah, but he didn't even come from any part of that constituency. The constituency included Bueju and part of Uganda, and he was from Uganda. Later we had Kamuntu, who was from Shema, and he was representing Bunyaruguru. But the people in Bunyaruguru saw that for the first time, here was someone from Bunyaruguru. By that time, Bunyaruguru now was a big county. Someone from Bunyaruguru.
Which is now President Derubiri's district, right?
President Derubiri's district. For the first time, someone was now in government. So I became the highest person from Bunyaruguru to be in government.
So what did you do? What did you do for the people of Bunyaruguru and at that level for them to say, okay, at last one of our own?
Yes, at last.
So when they look back, what is it?
They were looking back to, they were saying, okay, so now when they expanded the NRC, so I got elected to represent now, formally, to represent them in the NRC. When we went to the Constituent Assembly, they elected me. When we went to the sixth Parliament, they elected me.
But is that the people of Bunyaruguru scoring, or it's Honorable Katureebe who is scoring?
No,
what
no,
is it for them? What was it? What was it
for them?
now?
Actually, you need to go down to Bunyaruguru.
Okay.
And
but you know your accomplishments.
People will tell you that if you look at the health center we have, this was done during this person's time. If you look at the Arabica coffee that we have, it was expanded on because it had been there before and had been destroyed during Ayman's time. If you look at the cotton expansion growing, if you look at the housing, the education, especially Gary child education, those were some of my projects that were dear to my heart. And you can actually see there's been a tremendous change in the lives of the people.
You know, in 2018, the Supreme Court gave the final verdict on the amendment of the Article 102B of the Constitution that removed the presidential age limit.
Yeah.
And President Museveni was given a lease, I suppose, to seek another term when he's beyond 75. Much as the ruling on the court based more on the Constitution being a living document, so it can be changed. But don't you think you tampered with the spirit of the Constitution, considering our tumultuous history?
And maybe.
And do you think?
And maybe.
And do you think the president, if you could put
yes.
this as well, do you think the president, who is now 76 and you're retiring at 70, do you think the president maybe should think otherwise? Because the office, I suppose, has a lot of. It's a rough and tumble.
No, actually, to answer your question, you need, first of all, to look at the reasons that were given by the various judges for their decisions, because we had a split decision. So you really have to study the reasoning for the judgment to be able to see whether we anybody interfered with the spirit of the Constitution or the law and so on. But having said that, service in the public service and service in politics sometimes are looked at differently. The Constitution, the Public Service Act, the Pensions Act say when you are a public servant, you reach a certain age, you retire. When you are a politician, people have joined politics even when they're 80. I could not see myself any philosophical reason.
You know the most important thing you just mentioned, right, Honorable, in my view, said the Constitution says if you're a public servant and you reach this age, you retire.
Yes.
The same Constitution also said if you are a politician and you reach a certain age, you retire.
Yes.
But the politicians change it.
The politicians,
they change it to suit their goals.
They can even change. I saw the other day my former Deputy Chief Justice, for him he still thinks the judges should serve up to the age of 75. If the politicians want to do it, they can change it. They can change the age. Nothing is cast in stone. They can change it to 75 or beyond.
Actually, I've seen the judges in America who are 80 or 85 or even 90.
I met a judge who, when I went to the Mitchell College of Law in Minnesota, I met a judge Leahy who had been appointed by President Lyndon Johnson in 1964, and he was still serving. So other countries regard it differently. In Tanzania, it is 65. In Uganda, it is 70. Tomorrow, it may be 75. So even with political office, the Constitution said 70 or 75. Parliament comes and changes it. For me, I don't see that is really the big problem, because you can have people older than that serving. Recently, you had a man who was 93 being elected Prime Minister of Malaysia.
Making a comeback.
And making a comeback. In England, a long time ago, you had a man, Sir William Pitt, who was elected Prime Minister at the age of 24, the youngest Prime Minister. So for me, depending on the country and what they want to do and what the Parliament wants to do, if they do it correctly, I think I have no problem with that.
You know, I ask that because I just wanted to know your opinion, because as somebody who has served at that level, you understand the burden and how heavy some of these offices are. And actually, the president is on record. I was lucky to sit with him, and he said, at 75, at that level, as a human being, really, there's nothing much you can do. He even gave some wise counsel that you people of Uganda, if you want somebody who is better, just look low, below. So I wanted to hear from an elder like you, whether you think he should have thought otherwise.
So I suppose you have gone back and asked him that question.
Yeah.
But speaking for myself, the roles are really different. Some people enjoy being a politician, and you see what politicians do. When you are a judge, the time, the job description, you don't go and address a rally. You sit and listen to people's evidence. You sit and listen to people's troubles. You sit and listen to people's cases, and you have to make a decision. And sometimes it's not as simple as many people think, making those decisions and writing out judgments and so on. So those who conceived the whole idea of the Constitution and the judiciary and so on thought that when a judge reaches this age, given the workload and what they do, should retire. Maybe when they have improved on the conditions of service, and the conditions of service, I'm not talking in terms of salaries and so on, but in terms of what office facilitations do you have. The American judges, you have given an example. When you go and visit them, you'll find each judge has maybe 3 or even 4 clerks who really do his work. They do the research.
I've actually seen them even campaign for those jobs.
We went for a training as Supreme Court judges at the Court of Appeal and the Supreme Court in the United States. And when it came to a course in judgment writing, the person who took us in that course was one of the clerks to one of the judges. It just shows you the extent to which those people are assisted. They get the best of law graduates, they make them clerks, they do the research, they originate the judgment. So the judge is assisted. If you take that one to a judge who has to listen and until recently is writing in longhand all the evidence, everything said in court, is the one going to do the research, is the one going to originate his draft, is the one going to proof his draft and read the judgment, I think the workloads might be different.
Talking about the workload, one of the issues that has been very common is the backlog in the judiciary.
Yeah.
And I'm wondering, when you look at the other arms of government, let's say Parliament, it's bloated with a big number of people, representatives, and they're now busy building an Ambola-like stadium kind of a parliament to be able to fit them in, and of course, the next time they're going to increase.
Yes.
Also, the cabinet perhaps is the biggest in the region. Why is it that you never increased on the judges? Because if you increase on the judges, then you are able to solve the issues of backlog. You have few manpower, and the other arms of government are just bloated.
Well, I'm glad you brought up this question of backlog. And earlier on, when I said some things you have done and the others you have failed to do, when I came in, one of my pet subjects I talked to was to reduce case backlog. And I even appointed a task force to ascertain how much case backlog we had, and then reappointed them as a backlog case monitoring backlog reduction committee headed by Justice Bart now. We really were enthusiastic to make sure that case backlog becomes a thing of the past. But two things have to be equal to that. One, you must have the necessary resources, the necessary manpower, because cases they can't be heard by computers. Cases must be heard by a judicial officer. And Parliament, I keep saying this, Parliament passed a resolution several years ago that the judges in the High Court should be increased to 82. And even the Treasury had promised that they would appoint 10 incrementally, so that by now we would be having 82 judges. We still have only 56 judges in the High Court of Uganda.
So in that matter, Right Honorable, were you failed by the executive? Would you say that the executive did not?
Yes, and
you were failed by the executive.
I was failed by the executive because I don't appoint judges. They appoint judges. Then the Treasury will say, we don't have money to appoint more judges. And last time when I was addressing the annual judges conference in front of the president, I pointed out, how can you be increasing the number of members of Parliament but not be able to appoint an extra 10 judges?
Considering that at your entry, you looked at the case backlog as one of the biggest problems facing the judiciary, and you were unable to, okay, somehow you tried what you could, but it wasn't totally solved, and the judges were not given to you. I'm sure you're not signing out with your head high, are you?
No, I think we have done some more, not as high as I would definitely want in terms of case backlog.
So on that one, you're quitting
we did
a little
not,
bit frustrated, are you?
Yes, we did not do what I thought we would do if we had had the necessary resources. That's the first aspect. If we had had the necessary human resources in terms of appointment of judicial officers, you look at the gaping holes in the judiciary, in the High Court, where you should have 82 judges, we have 56. In the Magistrates Court, where we should have a total of 500 magistrates, we have 300. So there are gaping holes, and those contribute to. But the other aspect is our own internal weaknesses as judges and other judicial officers to work. There are people who don't really put in that much work, I should say, in terms of disposing of the cases they have had.
But this is an area that was right under your docket that
Yes.
you could have changed. Why didn't you?
I think we have. But
in your retirement, you're saying there are people right in the
they are
chambers
still there,
who are not even doing their
yes,
part.
they are still there, and they are going to be there. We have discussed with the team, with the principal, the incoming principal judge and deputy chief justice, on how we can improve on that. It's a long-term program.
So on the increase of the numerical strength of the judges and the failure for you to get the numbers that you want, was it an issue of resources or the political will?
I think it is the resources. The answer that we have often been given from the Treasury is not enough resources.
There are enough resources to give us 500 members of parliament. There are enough resources to give us the biggest cabinet south of the Sahara, and there's not enough resources for the judges, 8 of them? And you still think it's an issue of resource?
That's the question I've given, but it is resources. We don't have enough money for the budget. We believe that now that we have passed through this administration of the judiciary bill that makes the judiciary now self-autonomous, we may even be able to...
Are you convinced, Right Honourable? Are you convinced, Right Honourable, when you say it's an issue of resources? People in your, in the judiciary are going to say, yes, this is it? Are they going to support you?
No.
Then why don't you tell us the right thing?
What we have been told is the issue of resources, because the budget process,
Do you believe them?
The budget process as it now is, you make your budget, and then the Treasury says we don't have money. And we go to Parliament, and we have been meeting with the members of Parliament, the Budget Committee of Parliament, and so on. They may increase a little there. So in that sense, it becomes an issue of budget resources. But the bigger picture, which you have harped on and I have harped on, is to see the judiciary as an equal arm of the other branches, as an equal arm to the legislature, to the executive, with a mandate given in the Constitution, which they must fulfill. That is administration of justice for the benefit of the people of Uganda. And there it may be a matter of either lack of political will or lack of understanding of our respective mandates, a combination of both, and then you fall back on not enough resources. So we have harped on that, and I am sure that even the next Chief Justice will harp on it. When I have been outside and talked with other Chief Justices and other judiciaries, there is always everybody saying they never get enough money from the executive to run the judiciaries and so forth. But I think time has come, and actually one of the things I've left on the desk is I asked the World Bank to analyze for us judicial expenditure and judicial investment in the judiciary, and what it means for the investment in the country and the economic life of the country when enough resources are not invested in the judiciary. And we've just received a final draft, which I think they will be presenting the final report from the World Bank on the 3rd of July, which analyzes what can be best done by the judiciary, how we in the judiciary can point our resources to be more efficient even with the little that we have, but most importantly, to point out what it means to the country when the executive and parliament don't invest enough resources in the judiciary. What does it mean to the investment climate when the administration of justice suffers because not enough resources are being put in the judiciary? So the question is multifaceted. Yeah.
Right Honourable Bart Katureebe, we're going to take a break. I'll be right back. Welcome back. You're watching On the Spot. My name is Patrick Kamara, and we are coming to you from Nyakisharara in Mbarara Municipality or Mbarara City, from the home of the retired Chief Justice, the Right Honorable Bart Katureebe. We talked about the issues of challenges in the judiciary, and the last 5 years, I've just remembered, there have been several murder cases. Murder, cases of high-profile individuals, including somebody, a judicial official like Joan Kagezi, former AIGP Andrew Felix Kawesi, and MP Ibrahim Abiriga. And, you know, their cases were never concluded. Who is responsible for the delay?
Well, when a murder is committed, or any crime is committed, first, you have people who are responsible for visiting the scene of the crime and doing the investigations. When they have completed their investigations, they have to submit their investigations to the prosecutors, which is the Director of Public Prosecutions. The Director of Public Prosecutions must be satisfied that he has a case that can stand in court. When he is satisfied that he can bring charges and bring a case to court, then somebody will be charged in court. Now, when he is charged in court, that person is entitled to a defense lawyer. If it's murder, if he doesn't have his own defense lawyers, the state must give him a counsel. That's one of the constitutional rights. The case comes up for scrutiny now. Okay. The courts work on evidence, nothing but on evidence. Many of the cases you have cited have not even seen the light of day in court because either the prosecution did not pursue them, charges were withdrawn, or people were kept until they were released on bail, because for how long can you keep someone in jail? The Constitution says 6 months maximum. So the failure to prosecute those cases must be found elsewhere. Must be found either the investigations were not adequate, because I know in one of the cases, or several of the cases, they arrested many people, put them on television, these are the suspects and so on. And then the charges were withdrawn. Not a single person, as far as I know, not a single person has been charged in the case of Kagezi or several of the other people. So now the courts, for us, we have no saying that. And when you bring the case of murder or any other criminal offense, what is the standard of the law? You must prove the case beyond a reasonable doubt.
But as the Chief Justice, when you say maybe prosecution didn't do their part, I want to agree with you, but would you say it without a grain of doubt that really these are the people who have failed you or have failed to bring justice?
Well, but if the matter has not been brought to the courts, or if they have been brought to the courts without evidence.
Yeah, but there's a high-profile Ugandan, murdered in cold blood, perhaps some people whom you know, and prosecution has not done their part. I think the Chief Justice can say you have failed.
No. You see, you are making a mistake of putting murder in terms of a high-profile Ugandan. Every Ugandan that gets murdered is important to us. Yes,
so, yes, Right Honorable. I'm only picking an individual that is a high name recognition that anybody can understand. Even now, today, I'm sure people...
And the police should investigate the case of a high-level person the same way they investigate any other person. Because you can make a mistake of going to go for a high level and ignore basic facts of investigation because you want to investigate.
So, Right Honorable Katureebe, what are these 3 things you have accomplished for Ugandans, the low-level Ugandan, who can say in the 5 years as you served as Chief Justice, this he did for us as poor Ugandans?
I think when you look at the performance of the judiciary as a whole, you will see that more cases have been disposed of than ever before in the judiciary. You will find that, for example, when I came in, and for a long time...
The number, by the way, you had even put a figure on the cases, about 100,000 plus? Of cases that were the backlog cases?
No, they're actually much lower than that. I think they are less than 50,000.
But what did you find?
115.
Yes. So you did half almost.
So we've done something there. But most importantly...
But we have to remember that this was one of your most standout goals
Yes,
to
but
achieve.
I have given you the parameters that one was expecting. But you're asking what has been achieved. More cases have been disposed at various levels of the courts, especially at the magistrates' court level, which is where most Ugandans go. Most people, they go the magistrate, grade 1, chief magistrate. Those courts have disposed of more cases than ever before. We now are beginning to see what I was going to say before, that as a result of the increased use of plea bargaining, we now have more convicts in jail than ever before these past 2 years. We have more convicts than remandees, which means the criminal justice system has managed to have more people convicted by the courts than having them on remand. So to me, if you look at that in the context of administration of justice, there have been some gains. What I was saying is we could have done more if we had all the resources that we needed and played our part. So there has been some improvement, definitely.
Just a day before you retired, the president assented to the administration of judiciary bill that allows former Chief Justice, his deputy, to retire with 100% of their benefits, and justices of the Supreme Court of Appeal, I think 80%. How do you think, isn't this being unfair to the other public servants?
You know, if you do your research all over the world, the remuneration of judicial officers is something that stands out because of the very nature of the work that they do. This bill has a long history. We based our memorandum to government way back in 2015 on the basis of what has been done by other judiciaries, more specifically Zambia and Tanzania in the neighborhood, where judges retire with 80 or 85% of the salary. Here, we didn't have anything in terms of what judges retire with. It was the general provisions under the Pensions Act in the public service. Even a Chief Justice, there was no provision in the law as to what the Chief Justice of Uganda retires with. It's just the period you served in the public service, like anybody else. Everywhere else, you have provisions. The Chief Justice, this is what your remuneration is when you are serving. This is what you retire with.
Is it by coincidence on the day of your retirement this is also made law that you can go the 100%?
The problem with you, Kamara, you are so impatient. You asked a question and I'm trying to give it to background. So when we asked that Ugandan judges should also be allowed to retire like those in the region with 85%, 80 or 85%, it is the president who replied and said, why 85%? They should get 100%. And the reasons he gave is that judges, first of all, they work so hard, they give up their practice, they don't participate in other normal business activities, they are restricted. And he gave a number of examples of judges who had retired and found themselves in a lot of financial difficulties. So the argument started
Even
from
the
there.
other public servants are leaving their tanks empty. They're working hard.
Let me first answer my question, which was to me. When I was appointed a judge, I had to surrender my shareholding in Kampala Associated Advocates, which, as you know, is one of the leading law firms. When I was retiring now as a judge minus this bill, I was going to get a pension only for the 15 years of service and nothing, not even a shilling as Chief Justice. If you look at that more closely, you will see what people are talking about. But that's not the point. The point is that we tried to mirror what other people do. You go to Kenya, the judges get much more than what we are getting even now. Now, the administration of the judiciary bill is not only about remuneration of judges. It has provisions about operationalizing the autonomy of the judiciary. And the idea started way back in 1998 when I was Minister of Justice. And I remember being summoned by then Chief Justice Wambuzi for a meeting with the judges. And we had a meeting in the library. And they said Parliament had just passed the Administration of Parliament Act. So the judiciary wanted something similar, and it has taken that long to come through. There are so many drafts that were debated. There were the financial implications and so on. So it so happened that Parliament has been on it, I think since March. Before March, it has been before Parliament.
Yeah.
So it is just a matter of coincidence that Parliament passed it, I think 2 weeks ago, and the President assented to it. So it is not that suddenly it came. It has been in the works since 1998. And it is not only about the remuneration of judges. It is about operationalizing the operation, which we believe that the judiciary will be much more efficient, hopefully attract even more resources by establishing a judiciary fund, which now can attract even funding from outside. So if the judiciary is further facilitated, the administration of justice in the country improves for the benefit of who? For the benefit of the people of Uganda. So that's what the administration of the Judicial Act is about.
Okay. There has been, as you sign out, I continue to hear increased, comments that there's a deliberate appointment of people they call cadre judges into these offices. And I think they say cadre judges because they suppose maybe people who are inclined to the NRM as a party. Do you think the appointment of judicial officials should be left to the Judicial Service Commission and maybe the public, so that you erase any grain of doubt and then they just go on through meritocracy?
Well, first of all, people should be appointed on merit,
Yes.
on meritocracy. But you are appointing human beings. And how one behaves as a judge, a lot depends on one's own disposition, one's own conscience, one's own training, one's own perception of his role as a judge. And there are people who may be appointed as what others think people as cadres turned out to be much more independent-minded than cadres. I think even in the United States, we are seeing commentaries saying this person was appointed as a conservative judge, but is siding with the liberals and so on. That can happen. You may have someone who is appointed knowing that is, I don't want to use the term, but not with the government, but ends up being the one that makes decisions that appear to favor government. The most important thing is you, when you sit as a judge, at least from my experience, when a case comes before you, it is you now. It's not about anybody else outside. It is you. It's your decision. And people will praise you, sacrifice you, or insult you, or whatever, for you, yourself. So, yes, people should be appointed on merit. The system should be examined, whether it is giving us what we really want, whether the Judicial Service Commission should expand its scope by inviting people to give comments or to give recommendations other than the restricted circle. But at the end of the day, when someone has taken his oath of office as a judge, it must be looked at for what he or she produces.
Now talking about the individual, standards and the values and maybe integrity of individual officers, which brings me to what I think is the elephant in the room, the question of presidential petitions.
Yeah.
Amongst the many petitions, to some, the 206 election stands out. The question of substantiality is what you relied on to determine the outcome of an election. Other legal scholars, like Professor Loko Nyango, look at the determination of presidential petition from what he terms the political doctrine. With growing jurisprudence in the region, including recently in Kenya, where the election was overturned, perhaps do you think the substantiality test may be waived in future?
I think each country should look at its constitution. Each country should look at its circumstances and decide what should be the criteria if you want to annul a presidential election and what are the effects of that. Why am I saying that? I'm saying this because in Kenya, you remember when they annulled the election?
Yes.
The next order they made was there must be another election held within 60 days. And you remember the people who should have won the election, the Ojinga Odinga group, then said, but the same electoral commission which has created this mess cannot be allowed to run the next election. So even within the 60 days, they boycotted the election. And the question remains whether the following election, which followed the rules, really produced the desired, the will of the people of Kenya. I think there is that debate still going on. In Malawi recently, they annulled the presidential election. But having annulled the election, they allowed another 150 days for the Electoral Commission to prepare another election. And they allowed the president to remain in office. And the election was held, I think, yesterday. 150 days, but the Electoral Commission had to go. They appointed a new Electoral Commission to run the election. Now, I remember after the Kenyan election, we met with the Chief Justice Maraga in Dar es Salaam at the annual Judges Conference, the Commonwealth Judges Conference. And we were all talking, and then I mentioned to him that, you know, if you had been in Uganda and you annulled that election, you would have ordered for another election to be held within 20 days. And everybody said that's impossible, you can't do that. It's illogical. How can you hold an election in 20 days?
Which brings me to...
Now, so that's why I was saying each country, you look at the whole provisions of the Constitution. Whether we were over-optimistic when we made the Constitution of Uganda, that you can say this Electoral Commission has messed up our election. They are the ones who are the culprits, but at the same time, they should organize for us another election in 20 days. What would happen? Whether they would do it? You can also subscribe to the school of thought, which says that should not bother the judge. Just declare and leave it to whoever.
So, right, Honorable.
So those are the questions that I think give rise to the recommendations that were made by the court for further scrutiny of our own constitution. Now, the substantiality test. The substantiality test is not introduced by the judges. The substantiality test is in the law made by Parliament, the Presidential Elections Act. So I think it is section 59. That's the law which says before you annul the election, you must be satisfied that the irregularities have affected the election in a substantial manner. Now, what we have all been left with is to decide, to interpret the words of the statute. So if you want now to change this legal reform we are talking about, electoral reforms, probably that's one of the areas that Parliament should look at. Should we continue to have those provisions in our statute book? What will the judges interpret? Can I say, as long as there is any malpractice in an election, as long as there is any malpractice at all, it should be nullified? Or should you look at how much must be there to affect
substantially
to be able to say, I nullify this election? I think even without saying substantiality test in the law and so on, even when you're in Kenya or in Malawi, the judges will still weigh the evidence before them, before they make that decision. So that's what I can say about that substantiality. There are people who have argued about the substantiality test as if it is introduced by the judges. It is in the law.
Are there some occasions when you are writing your judgment and because you are facing some constitutional challenges, like in this case where it's giving 20 days to maybe hold another election, you say, look, maybe I may not do exactly what is right, but let me take this route because it may save a country from anarchy, from crisis?
I think this is something that is debatable. As I said, one school of thought is saying, you judge, if you are satisfied this is the position, just declare, nullify. What happens has nothing to do with you. Now, others say, what happens definitely has something to do with you. Because if you are going to decide in the interests of the people of Uganda, their norms, their aspirations, and so on, why shouldn't the judge think of what are the consequences of what he decides? It's a debatable point.
So sometimes a judgment may not be wholly into the legal norms. You have to look into what could be the implication.
No,
you can do a little bit wrong to save a country. Is that what you're saying?
You are looking at the evidence you have, because Is it really 50-50? Is it 60-40? Is it 80-20? It is the evidence that must decide the opinion of each judge. And that's why you have had split decisions.
And the legal profession, we know it as a very noble profession, right, Honorable, but we see a growing number of people who are not, don't have public trust because of issues of corruption into the hallowed and noble profession.
Yes,
I wonder what you do make of that.
No, I think we have, as a country, to recognize we have a very serious problem of corruption. Corruption has eaten into all aspects of our lives. In the legislature, in the executive, in the general public. And it would be a lot of wishful thinking to say that the people we appoint from the public and to become judges suddenly will be holy. That's why scrutiny of whom you appoint becomes important. If I have been a lawyer whom many people think is not a straight lawyer, and I get appointed as a judge, will I forget about the habits I was having down there? If I have been someone who comes and finds his way to become a magistrate, not to do judicial administration of justice, but to make some money. I have had people who, in the past, who have talked to me, friends and lawyers, who said, me, I'm in this thing to make money. If you are a holiday, you go and sort out your own problem. So
these are people in your network?
Yeah, when I was still practicing, there's somebody who told me, several, who had been accused of taking money from both sides, and I tried to intervene. They said, well, we are here to make money if you have something else. So if you become a judge to make money, if you become a magistrate to make money, then you probably shouldn't have been in that calling. But most importantly, you also have our own people who believe that they must offer something to judicial officers before they are heard. And you have tempters from society. And the problem now we have is that those who give a bribe to get something, to get justice, don't want to talk about it. Those who receive don't want to talk about it. Very few people see it. So we know that sometimes it does take place. There are cases we have referred to the Judicial Service Commission, and the Judicial Service Commission doesn't find the evidence.
There was a suggestion from, I think, Professor George Kanyehamba, who suggested there should be some kind of a commission of inquiry. Coming from him, a man of substance, a man in the background where you come from, don't you think this should have been listened to?
Well, I wasn't responsible for appointing a commission of inquiry. You can appoint a commission of inquiry. They have done so in Kenya.
Did he bring that to your own individual attention?
No, he didn't. But they have done so in Kenya, as you know. They had that big inquiry. I think Professor Kanyamba was even part of that. And at first, everybody thought things went very well. But there are those who are now calling for a rethink of that method of work. So the commission of inquiry will have its limitations. And if we go by what we have seen in this country with commissions of inquiry, you can appoint a commission of inquiry that may go on, and it ends up becoming a witch hunt on some people and so forth. It may not serve the purpose. But if the government determines it should be, it's okay. Let it be there.
Right, Honorable Justice Bart Katureebe, we're going to take a break and we'll be right back. When we come back, I just want to ask the issues concerning torture. Should these officers involved in the cases of torture be held individually culpable, and that perhaps can prevent torture in future? We'll be right back. Welcome back. You're watching On the Spot. My name is Patrick Kamara, and we are coming to you from Nyakisharara in Imbarara Municipality of Imbarara City, at the home of the retired Chief Justice, the Right Honorable Bart Katureebe. Torture is something not acceptable in the Constitution, but we have seen that it's widely used by officials of in police, in the military, for them when they want somebody to give evidence. And we currently have the Prevention of Torture Act. Do you think that now that they want to specifically target individual officers to be, individually culpable for the offenses they've committed, that will in a way reduce cases of torture in future?
First of all, as you quite rightly said, the Constitution prohibits torture. It's a non-derogable right. You have freedom from torture is non-derogable. And anybody who breaches that should be held accountable. And if he claims to have done so on behalf of the state, and the state owns up to that, then the state should be held accountable. But I think it is right that individuals who engage in those acts of torture, which is outside the Constitution, should themselves be held accountable. The problem, though, is that when it's an individual policeman who has tortured you, and when it comes in terms of collecting damages from him, compensation, he may not be able to do so. So somebody should be able to fall back on the principle that if you did this in the course of your duty or as an officer of the state, then the state should be held responsible for your acts. So that is the debate. Whether the state should be also held responsible for the criminal acts of the officers, that will be established.
Can there be a hybrid where the individual is held culpable, but the state can also get involved in the compensation?
Yes, there can be, because I said if he was in the course of his employment, there can be room for interpretation that he was a policeman on duty. His officers should have made sure that he didn't do what he did. The bottom line is we must really, and I've said this before, when we put that in the Constitution, if you look at the preamble to the Constitution, we are looking at what the history we had gone through, where people were tortured, people disappeared without a trace. People were burnt and maimed for life during Amin's time and so on. So when we came to make the Constitution, we put that right to freedom from torture is non-derogable under any circumstances. The right to fair hearing, so that somebody is brought before a court and the evidence produced against him is presented to him in court and given a chance to rebut it. They are non-derogable. Once that culture is taught in the executive, in the army, in the police, in the state attorneys, us in the judiciary, all those who are involved in administration of justice, and to know that when you are culpable, we may say you yourself answer for this, all right? We think that should, and I think that's why Parliament passed that act.
The other issue in Uganda, I think that is very serious, is Uganda's land question. And quite a number of people you find they are displaced on their land. They have lived there since their lives, maybe ancestral land, and somebody comes, maybe has money. The rich and powerful have often been seen to evict people off their land. And sometimes they go to court, but the poor do not get justice. When it comes to matters of land, as if justice is only for the rich.
I think the land question is very, very complex. And that's why the president appointed the Catherine Bamgemereya Commission. And I believe among its terms of reference was to study the law, to study what has been happening, and give recommendations on what reform is necessary. I think we have to revisit the land question as it exists in the Constitution, as it exists in the Land Act, in a very fundamental way. And I believe all of us are waiting to see the recommendations of the Bamgemereya Commission. I think they have spent the last 3 years on it, so probably they have got more wisdom about it from their experiences in the field and from the information they have gathered. But the land question has to be restudied. And what does it mean when you say land belongs to the people? So land belongs to the people. So if this is my land, as it is, I have freehold on this land. If you want to pass the railway here, say pay me. That's what the Constitution says. Now, then you find now a conflict. The government wants to build, but it's also my livelihood. If you want to pass the railway through here, where do I graze my cows? Now, that is already one of those situations where government projects are being delayed because of disputes over the land question. as you have said, someone buys land. I have bought land, I have an interest called mile or freehold. But there are people there. They call them the Banja holders or Basens and so on. Now, in this modern world, I want the land because I want to build a hospital, I want to build a school, I want to build a factory, in this modern investment. But the old law says you may not touch this Chibanja holder. That conflict, how do we resolve it? I think you even
Is it now a land tenure system that is
I think we have to look at the land tenure system in its entirety. We have to look at the land tenure system, and we have to look at the Land Act, how it deals with it. We have to look at the Constitution, how it deals with it. We have to look at the land usage, planning, or I think all those are questions that I believe the Commission will give guidance.
What do you make of, I think, the Land Act, which will give security of tenancy to people, for example, migrated, use the example of Buganda, and you've been on the piece of land for 12 years, and the law is giving you security of tenancy, even though in the beginning the land was not yours. Somehow looks like that could take away the freedom or the ownership of land from the original landowners.
There are many questions even related to that. Someone sold land when you're still alive. There's an agreement. The person who bought has now settled. 15 years down the road, the sons now, the administrators of the estate come and say, we were not aware that our father sold this, get off. Those cases are also in court. You have cases of succession. Recently, I think we had a case where the succession dispute dates back to the 1930s. So all those are coming up now. You have people now coming up and claiming land where Makerere has been sitting since 1922. What has happened? So I cannot give an answer myself because I haven't studied it as much as the Commission has. So I think we will wait for the Commission to give us the recommendations, their findings and recommendations. But in my view, we need a rethink, a debate on this issue of land.
Okay, there are people who had proposed that if it wasn't for the coronavirus pandemic, probably by May would have had a national dialogue. What is your take on having a national dialogue? Because I suppose even the issue of Uganda's land question can be brought into the national dialogue, then people can candidly speak about matters.
Well, it would be good to have a national dialogue. I don't know whom it is anticipated will participate in it, but I told you from the beginning that I was subscribing to the idea of the Moshi spirit of 1979, and which gave rise to the UNRF. And I thought it was not a good idea to break up the UNRF. I remember very well the Daily Topic, what's it called, the Daily Topic? The weekly topic newspaper, which had President Binaisa holding an umbrella of the UNRF. And the various political parties, DP, UPC, UPM, had pierced through the umbrella. And he was saying, no matter what happens, I'm going to repair it. That was UNRF. But I thought it depicted very well because we thought that umbrella was giving room for national dialogue. There are still so many factions opposed to Amin for different reasons. But you know what happened? Within 68 days,
but if we are to have a dialogue, you have a group of people who have been running the state affairs for the last 35 years. Now they want to extend to 40.
They will come in as a group.
Yes, I'm saying yes, but the other individuals,
let me tell you what I think.
They have matters of accountability. The other individuals would want to dialogue them out of power and may not be acceptable.
Now you see, this is where I think you overjump yourself. If the national dialogue, first of all, it should be agreed what is it we are going to dialogue about.
The agenda.
What's the agenda? Is it the land question? Is it political reform? Is it legal reform? Is it electoral reform? What is it we are going to dialogue about? And who are the parties to the dialogue? Now, if you are talking of the group which is in power, it should come as one of the groups. It should be identified and it should be listened to, as much as the other groups should also be listened to. If you come in not prepared to listen to this group, and you come saying, we want them to get out of power, and they also say, we want to stop you from getting power, then what's the point of having a national dialogue?
You're right. Right, Honorable Bart Katureebe, do we have a leadership problem?
Where?
At the national level?
I don't think so. I don't think so. I don't think so.
In your view,
I think we have teething problems.
teething problems?
problems.
You teething for 35 years?
Teething
like
problems.
taking baby steps
Yes, yes.
after 3 decades?
Yes, indeed. Because I don't know how long it takes to build a country, to build a state. It does not have to be one government. It does not have to be one person. People have. You can take the other extreme of Italy, where they have changed governments, I think 52 or whatever times since the Second World War. But because the state had already been built, you see, we don't know in Uganda, it is debatable to what extent you can say we are a state. But because a state, the pillars, what should be the challenge for the government meaning not only the executive, but even parliament, the judicial, and all the other branches of government, to build pillars of the state, which can support the state. So that if one government is removed today, there is no collapse of the other instruments. Because what has happened here, you have seen. When Obote was overthrown, the Uganda army was regarded as Obote's army. Young men who had joined the Uganda army to make a career in the army suddenly were dubbed Obote's soldiers, and you know how many people lost their lives because of that. The other people who genuinely joined the Uganda army during Amin's time, they were all dubbed Amin's soldiers. Now we have Uganda army soldiers has been joining, and they are being dubbed Museveni soldiers. Shouldn't you have a dialogue where you say there must be a state called, a pillar of state called the Uganda army, whatever name, and which can survive whoever is president without me as an officer being dubbed so and so, Katureebe so and so. I think that is where we have to go. The judiciary. Katureebe has come, made whatever his contribution has been. Somebody else is going to come in. We must strengthen the judiciary so that whoever is Chief Justice, whoever is Principal Judge, the judiciary stays doing its work. Parliament, as an institution, today you are elected, tomorrow you are not elected. The most important thing is that the institution of Parliament must be strengthened so that they do the work they are supposed to do.
What you're saying that the doctrine of the separation of power should be robust. But,
yes, of course.
But the other day we saw military men coming from the wing of the president's office, coming to Parliament, thump the members of Parliament to pulp, and then we have seen people released from courts of law, immediately, arrested. At one point we saw members of the military, almost
now
going into
the question is
into
the fact that these have happened.
The hallowed grounds of court.
Yes, the question.
That's a crisis, right, Honorable Justice?
Yes, the question that we have had a crisis. Does it mean it should be perpetuated? Does it mean it should continue? Is there any country in the world which has not gone through a crisis?
It points to leadership. To me, it points to a leadership problem.
The strength of leadership must be in how you get out of a crisis and build on it and make sure it is not repeated. But you can't say because there was a crisis, therefore there is no leadership. It is how you get out. Each one of us in our lives, in our families, we have had crises. I think the strength of the individual, the strength of government is how you get out of that crisis. And well, those are some of the things in the national dialogue where I would expect people to say, this happened. Can we ensure that we now put in place X, Y, Z to ensure that they don't happen again?
All right. As we try to come to the conclusion, I think I would need to ask something that is of present concern. We saw the Electoral Commission give what they call a new roadmap that would require intending candidates to maybe campaign through digital media or radio and TV. Do you think this, if it is used, really will give us an election that is credible, that is fair?
Well,
and that won't disenfranchise the people?
Now, again, we go back to that. When I said each country, you must look at your circumstances and so on. If the situation is such, and here I have to be guided by the experts, that it is feared that to have 10,000 people in this compound for me to address them may become a public health hazard, and people may die because of that. it is something that the leaders of this country in the parliament and the executive must address. Maybe there is need for the parliament to enact a law that should guide all this, the roadmap we are talking about. It should be, in my view, those are things that should be put in a law, which is debated and passed so that everybody knows. That's my view. But you cannot run away from the fact that if there is danger there, I don't think I will go and stand before that car if you tell me there's a lion behind it. I will not go. Self-preservation. And look at the way people's businesses have been abandoned. People's businesses have collapsed. Hotels have collapsed. The offices have collapsed and so on because of fear of this disease.
Maybe must you decide for them without talking to them?
Wait a minute. If it is a matter of disease, I don't know whether you can say, let's vote democratically whether we should die or not. Whether this disease will affect us or not. Because it's a scientific fact. If there is a pandemic, it is a pandemic. If people are dying, they are dying. If you want to prevent, there is someone under the law who has been given the responsibility to make sure that people don't fall sick and die. I think now Parliament should debate this thing with an open heart. If it means passing a law, then pass it. And if it means postponing the election, they know what to do. If you find it is totally impossible to hold an election, as it might as well be, they know what to do. The Constitution makes provision for all those things. But we can't run away from the fact that where there is a question of life or death, there is a disease, and a contagious disease, certain measures are being proposed in that connection. I think in good faith we should all say, okay, let's debate it. What's the best way to go about it? I, for example, have a problem with people campaigning when I was, in my experience when I was campaigning at one time. The radio stations were very limited, you know. But you couldn't go and campaign on someone's radio who is opposed to you. They will not give you the time. So if the Electoral Commission does not have stations of their own, under which they will say each candidate must have half an hour of this time or something like that, and the radio stations are privately owned, I think you will need a law that compares them to give candidates equal time. So these are debates, but you cannot run away from the fact that if there is a pandemic, it is incumbent on the government, it's incumbent on you and me to make sure that now we've been sitting here without a mask. I'm sure we have safe distancing. But those are some of the things really that must be done.
Yeah, but
it cannot be
the biggest challenge, though.
You can't say because we did it in '96.
I'm sure you listened to the chief executive when he was addressing the country on the issue of education, and he was coming with a suggestion that perhaps we can buy radios and TVs so that students can learn. You know, TV states for a village 1 or 2. That's also an admission that the radios are not there and the TVs are not there. But how do you use the system?
Yeah, now that plays into what I've been saying. When you have an unusual situation, we put our heads together to see what can work for us. What can work? We need the kids to go to school. But you can imagine if you opened and children went back to school, and the next week you people report 10 kids have died in this school. Then everybody would be up. Why did you start in the first place? Why did you open in the first place? So these are a dialogue where now the Electoral Commission, Parliament, the executive must dialogue. We have this situation. What's the best way to go about it and still have a credible election? I think that's what I had people have been asking for.
I'd want to thank you so much for your time and appreciate your insights.
What's
going to be your parting shot?
What will be my parting shot?
Yes.
My parting shot is for all of us who have been given a chance by God, really, to lead the country in one respect or the other, as the president, ministers, judges, chief justice, legislators, and others. To think of the country, that it is bigger than us. The country is bigger than us, and we are allowed so much time to do what you can, and when your time comes, let others also try. And I think by putting together our ideas, as citizens that this is our country. We don't have any other. That spirit of Moshi should revisit us. And we talk about Uganda. And I think the idea of a national dialogue would be welcome for me.
Well, thank you very much. It's been an honor for me and for NTV Uganda for allowing our cameras into your home, this serene and beautiful environment, to find you in this cool and calm and collected kind of manner, complete with a cowboy hat. We thank you very much.
Yes.
And a man who has served Uganda with distinction, and of course, I'm sure, an icon for many. Good night, and God bless Uganda.